Morning. Hello and welcome. If you are a student curious about how privacy laws are shaping the digital economy, or a professional navigating compliance in your industry, or a business leader responsible for safeguarding user data, this series is for you. In this video series, we'll explore India's landmark Digital Personal Data Protection Act 2023, a transformative law that defines how personal data is collected, stored, used, and protected in a digital era. But we are not just scratching the surface. This is a deep dive across 8 focused parts where we break down the impact of the DPDP Act on some of India's most data driven and compliance sensitive industry, namely the BFSI sector, where consent, risk, reporting rules are redefining how banks and insurers operate. We look at IT service industry where global delivery centers must align with both Indian laws and client expectations. We'll then look at the healthcare sector where patients' rights and sensitive data demand ironclad protection. We look at the hospitality industry, wherein managing trust, identity, and personal preferences of millions of guests is paramount. We'll then look at the educational sector, where children's data is at the center of privacy enforcement. We'll then touch base on the world of marketing and sales, where consent is now the backbone of every outreach strategy. And finally, the social media industry, navigating new restrictions around profiling, tracking, and child safety. So, whether you are preparing for compliance in your organization or simply want to stay informed, this series is designed to simplify the law, contextualize the impact, and guide you through practical next steps. So, grab a cup of coffee, stay tuned, and let's together decode the DPDP Act one sector at a time. Welcome to part 4, Digital Personal Data Protection Act and its impact to the health service sector. As part of this video, we will be looking at the introduction, why the health service is highly sensitive, classification under the DPDP Act, key DPDP compliance requirement for healthcare, handling children's health data, impact on hospitals, labs, and digital health startups, cross border health data transfer, sector specific challenges and ambiguities, strategic compliance action for healthcare provider, opportunities for health sector, and DPDP compliance checklist for the healthcare sector. We'll wind up with a conclusion. So, why the health sector is highly sensitive? Well, it processes deeply sensitive personal data, which includes your medical history, prescription, diagnosis, and biometric records. There's a rapid rise in digital health platforms, which includes wearables and telemedicines. They often deal with emergencies and life critical data handling. And they are subjected to overlapping regulations like the MCI ethics and so on. Let's look at classification under the DPDP Act. While it is similar, let's look at it again. Starting with the data fiduciary, it determines how and why patient data is collected. Example, hospital, diagnostic lab, insurers. Then we have data processors. It is processes data on behalf of the fiduciary, that's you. Example is healthcare SaaS provider, cloud platforms, etc. Then you have the significant data fiduciaries, which are large health networks or platforms processing high risk or massive data volumes, which include your telehealth networks, e pharmacy chains, etc. Let's now look at the key DPDP compliance requirements for healthcare. The first is consent and notice. You must be clear, informed, and easily revocable, even in OPDs and mobile apps. That's the first. Then, special care are needed for sensitive data, whether it is health data by nature, it requires higher safeguard and minimal sharing. Next is emergency processing allowed, but explicit allowance for data processing without consent during emergencies are expected. From a data minimization and purpose limitation perspective, you cannot collect more than what is required. Example, date of birth may be needed, but why PAN? The next aspect is breach reporting. In this, the data leak must be reported to the affected individuals and to the board within the 72 hours as per the draft rules. We expect the draft rule to have a revised time, but at this stage it is 72. And then you need to have a grievance mechanism. That means it must allow patients to raise complaints digitally and get a timely response. So these are few of the key compliance requirements from healthcare perspective when it comes to DPDP Act. Next is handling the children's health data. It would require a verifiable parental consent. Just stating that I have parental consent will not gel. You need to able to prove that it was indeed provided by the parents. Enough evidence beyond doubt, beyond any reasonable doubt. When it comes to children's health data, pediatric hospital, vaccination app, and teen health program must also comply with this. Just this is a very broad brush. Literally every combination where a child is involved gets into the DPDP Act. There can be no behavioral tracking, targeting, or profiling for under 18. These are the top level aspects from a children's health data perspective. Now, what's the impact? For hospitals, you need consent. Consent would be a major impact area. Next is breach management, then EHR governance, and vendor control. Major challenges for healthcare sector. When it comes to diagnostics, you need consent for sample link data, data erasure post reporting. You would need, from a telemedicine app perspective, you need a digital notice, a parental control, an auto logout and encryption. If it is a healthcare startup, you need an SDF risk if scaling. You need a vendor compliance, you need an R&D use limitation. If you are having a wearable or an IoT device, you need a consent management in the first place. You need an edge data security. You need an opt-in for data sharing. Today you have a wearable, you just go and have it, install it, wear it off. But post this implementation of DPDP, all of these require certain few steps before it is even implemented or before use. A major overhead for this sector. From an insurance link health portal perspective, you need low role clarity, consent replay, compliance with IRDI and DPDP. From a cross-border health data transfer perspective, while it is allowed by default under DPDP, it can be restricted to specific countries by the Indian government as per the blacklist model. Many platforms using foreign cloud provider must track this blacklist closely to be in compliance. Let's now look at sector specific challenges and ambiguity. Well, Government may exempt under national interest clause certain public health programs. You may need fresh consent unless anonymized when it is about research or clinical trial. The National Health Authority has a separate protocol on data exchange, so it will overlap with ABHA and NDHM. Medical ethics and data privacy must be harmonized. This would be the doctor patient confidentiality aspect. Teens may require special provisioning. While DPDP applies anything less than 18 years blanketly, you need an approval. Let's now look at strategic compliance action for healthcare provider. You need to redesign your consent. On paper, web, mobile, all must be informed and easy to revoke. From a breach response perspective, you need to align with DPDP and CERT-In. From a staff training perspective, the doctors, the nurse, lab technician, they all need to be trained on data confidentiality. Because if there is a leak, this is one of the weakest area to come in. Though educated, they might not be educated in this aspect. So a training would be required and we need to demonstrate that we have. The vendor contract might need to review when it comes to cloud, pathology system, EMR vendors. They need to be updated to include the DPDP clauses. You need to relook at your design to bring in privacy, which includes your encryption, session timeout, minimum data collection, and so on and so forth. And you would need an appointment of a DPO if there is an SDF, especially for multi-location hospitals or aggregators. This gives you a perspective about the challenges this space is going to have and the cost and the overheads that are going to come in. But being a very sensitive area, these are something which is required to be in compliance, protecting the interest of an individual. From an opportunity perspective, this would build patient trust through transparent data practices. It offers consent-driven patient portals with download and delete options. It would help monetize de-identified health data for R&D ethically post DPDP compliance. It gains global alignment with GDPR, HIPAA for international credibility. Let's now look at from a checklist perspective. There are a few areas that would be requiring attention, starting off with governance and organizational readiness aspect. The first thing is form a data privacy task force involving clinical, IT, legal, compliance, and operations leader. Designate a data protection officer while it is mandatory for large hospital chains or digital health platforms. But as a best practice, you can have that even if you are not in a large category. It helps. Classify the organization for significant data fiduciary applicability. Identify all roles handling personal health data across the organization. Establish board level oversight for privacy and data protection policy. So that's the first step. Once done, we move to the second aspect of data discovery, classification, and mapping. Create an inventory for all personal and sensitive health data handled, which includes your patient's medical history, diagnostic results, prescription, insurance detail, and biometric data. Then classify data as per data type, its sources, where it is used or usage, and their risk level. Map the data flow across the EHR, labs, billing, third-party systems, and mobile apps. Identify all systems processing children's and elderly patients' data. Once you have covered these, we move to the next aspect of consent and notice framework. In this, you need to ensure explicit informed consent and is collected before any data use. This is before. You redesign paper and digital consent form for OPD, IPD admission, for your diagnostics, for telemedicine, for research participation. You need a serious redesign from a consent perspective. You need to provide multi-language consent notice, including use of the data for what purpose, which is treatment, for billing, for insurance, for research, if applicable. You need to enable easy withdrawal of consent, especially in mobile health apps. While easy withdrawal consent is expected from all the sources that you have. Once you cover this step, we move to the next of data principal rights management. In this, you need to create a portal or a desk where patient can view their data, request correction if there are errors, or ask for deletions. You need to build SOPs for identity verification before fulfillment request. You need to set SLAs for responding. You need to include right to nominate for incapacitated or deceased patients. You need to maintain audit logs of all patient requests and action taken. Once you cross this hurdle or this step, you move to the next, which is data minimization, retention, and the deletion aspect of it. In this, you need to review and minimize the data collection. You need to set your data retention policy, which should be aligned with the MCI and IMC record retention norms, your insurance regulations, and your research mandates. You need to implement automated deletion for records post retention period. You need to ensure deletion from the system, which include your EMR or EHR systems, or your imaging systems, or your backups and logs. Once you cross this, then you come to the data security and breach response aspect. In this, you need to review information security control to review if it is in line with your DPDP and certain expectations. You would need to implement encryption of medical records. You need to implement role-based access to health system. You need to implement audit logs for data accesses. Then you need to build or update breach response plans. You need to notify affected patients and board within 72 hours. You need to coordinate with certain if needed within 6 hours. You need to run breach drills involving IT, nursing staff, and legal teams. So that's the data security and the breach response aspect. Once you cross this aspect, you move to third party and vendor management. In this, you would need to identify all third party vendors with access to patient data, which include labs, radiology services, insurance, TPAs, health SaaS provider, etc. You need to review and update your vendor agreement, and it should include your breach reporting obligations, consent requirement, deletion obligations upon exit. You need to conduct risk assessment and audits of high risk vendors. Then you need to maintain a data processors register and ensure onboarding includes privacy compliances. Once you cross this step, As part of a checklist, you would enter the children's data and sensitive health information area. In this space, you need to ensure verifiable parent consents are in place for data of patients under 18. You need to block behavioral tracking, profiling, or targeted health ads to minors. You need to define boundaries for adolescent data use, especially in mental health or reproductive care. You need to seek guidance for processing in verifiably safe mode, wherein exemptions are required. You need to seek guidance. Once you cross this aspect, you enter the research, insurance, and public health program aspect. In this, for any clinical trials or R&D, you need to ensure consent covers secondary use. The data are anonymized, de-identified wherever possible. For insurance linked processing, ensure joint fiduciary responsibilities are clearly defined. You need to monitor use of data in government health schemes. You need to watch for exemptions or partial compliance area. Post this, you need to look at the digital health platform, and these are specific actions. You need to review all mobile apps and portals for consent, privacy notice, and data tracking. You need to include opt-in for data sharing with third parties or analytics tool. You need to protect the data collected by teleconsultation firms, the wearables or IoT health devices, or the remote patient monitoring tools. And you need to implement session timeouts, two-factor authentication, and secure the APIs. The next aspect is training, awareness, and ethical alignment. In this, you would require to conduct mandatory training for doctors, nurses, lab staffs, and admins and registrars. You need to train support staffs on grievance redressal and patient rights. You need to update the code of conduct and medical ethics standard operating procedures to include privacy responsibilities. You need to conduct periodic privacy awareness campaign for employees and patients. Once you cross this hurdle is where you move to the auditing, reporting, and continuous monitoring aspect. In this, you would need to maintain a privacy compliance dashboard which is monitored by the data protection officer. You need to record the consent logs, grievance tickets, DPIAs, and breach events. You need to review compliance quarterly at leadership level and would need to stay updated on the MIT notification, Health Ministry circular, IRDI, and NHA guidelines. I hope this checklist helps you in your planning and strategy and clear actionables. Do note, these are something which should be built in your current. Do note, these are not something which is been listed out as mandatory, but this supports the DPDP principles. These are thought process, a checklist from a place where the breaches can occur, how it can break your process and potentially cause harm in terms of reputation or penalties. So these checklists are to help you think through, trigger your thoughts, and plan your strategy as to how are you going to ensure compliance to the DPDP Act. So that's how you should look at these checklists. I hope this again helped you in some form and shape. Let's take a sector by sector look at how the DPDP Act 2023 impacts different industries. Because compliance isn't one size fit all. I have compiled a comparative table covering BFSI, IT services, healthcare, hospitality, education, marketing and sales, and the social media industry. So let's break it down. Consent management. Well, consent is the cornerstone of DPDP Act, but its implementation varies. In BFSI, consent must be tightly managed, especially for KYC, biometrics, and financial information. In healthcare, it's even more sensitive. Patients and parents' consent is absolutely critical. For marketing and social media, consent isn't just required, it defines whether your outreach is legal or violation. When it comes to children's data, this is where the act is more stringent or most stringent. Educational institutions and social media platforms are directly in the spotlight here. Under DPDP, profiling or targeting anyone under 18 is strictly restricted. And verifiable parent consent becomes non negotiable. Do note, verifiable. The organization need to have a mechanism where it can prove that the parental consent was indeed from the parent. Next, on the data rights enablement perspective, all sectors must now empower users to access, correct, or delete their data. That means banks, schools, hospitals, hotels, and even digital marketers need process and tools to honor these rights, preferably through user friendly portals. When it comes to breach notification, every sector is now bound to notify the Data Protection Board, and in most cases, the affected individual within 72 hours of discovering a breach. In healthcare, this could be patient's record. In hospitality, it could be passport scan. Or for social media, a profile leak or consent compromise could trigger serious reputational and legal consequence. When it comes to third party or vendor risk perspective, here's where the rubber meets the road. Whether you are a bank outsourcing IT, a school using a learning app, or a marketing team working with an agency, the DPDP Act expects you to own the responsibility for your vendor's privacy posture. Data processing agreements and audits are no longer optional, they are essential. When it comes to grievance redressal, the DPDP Act mandates every organizations to have a clear, accessible grievance mechanism. This might look like a chatbot, an email, or an in-app feature. And it's especially critical for social platforms, hotels, and edtech apps that serves diverse digital first users. Well, likelihood of being classified as a significant data fiduciaries? Well, lastly, we assess the SDF risk across sectors. It is high for BFSI, IT, healthcare, and social media because of the sheer volume and sensitivity of data they process. For educational and hospitality, it is medium to high, especially if you are running large networks. And for marketing, if you're handling mass personalization and cross platform tracking, the risk goes up fast. So, as you can see, while the principle of the DPDP Act remains universal, the real world implication differs greatly Depending on the sectors, some industry will need to overhaul their tech infrastructure, while others will need to fix their lead generation or outreach tactics. But for all of us, it's a journey towards being more transparent, ethical, and user centric data practice. In the next part, we'll deep dive into each sector one by one. So stay tuned and don't forget to like, share, and subscribe if you are finding this series helpful. Do note this slide we will come again and again on all the modules that we are going to discuss. So, in case you have missed out or you need to have a better context, so when we look at BFSI and IT services and all the other areas, we will refresh this slide again and the context. In conclusion, the DPDP Act raises the bar for privacy first, trust building healthcare systems. Compliance isn't just about avoiding penalties, it's about respecting patients' dignity, enhancing data ethics, and aligning with global digital health standards. The DPDP Act reshapes how patient data is handled, stored, and shared in India. It demands accountability, transparency, and strong digital safeguards, not just from digital startups but also from traditional clinics and hospitals. Early compliance will protect patients' trust and prevent costly penalties. Healthcare sector entities that adapt quickly will lead the way in building privacy first digital care ecosystem. With this, we come to the end of part 3, wherein we touched the impact of health on health service sector from a DPDP Act perspective. I hope this has been useful, has provided you some basic input and insight, an idea as to how you can go about implementing this in your organization. Some of the aspects I've tried to cover, while not comprehensive maybe, but then it gives you enough trigger point to think through and strategize. So this is your host Savit Vittal Salian closing this part of the session. I'll catch up with you in part 5 where we'll take a new sector which is impacted due to the DPDP Act. Thanking you. This is your host Savit Vittal Salian. Namaskar.